Constantly appearing in at least 7 of the presidential petitions filed at the Supreme Court is the need to invalidate presidential results as announced by the IEBC. According to Article 140 of the Constitution of Kenya on questions on the validity of a presidential election, a fresh election shall be held within 60 days if the Supreme Court determines the election of President-elect to be invalid. But the petitions by Raila Odinga, Okiya Omtata, amongst others, invite the court to go beyond Article 140, Sub-Article 3, and instead borrow from Section 80, Subsection 4 of the Elections Act. According to the section, an election court may by order direct the commission to issue a certificate of election to a president, a member of parliament, or a member of the county assembly if, upon recount of the ballots cast, the winner is apparent and the winner is found not to have committed an election offence. The petitioners want the court to grant Raila Odinga the election certificate should the ballot recount indicate that he is the apparent winner.
That is the shortcut. You can't use an Elections Act to give somebody a certificate when the Constitution is so supreme.
South Mugirango Member of Parliament Silvanus Osoro has already moved to the High Court under a certificate of urgency to have the clause of the Elections Act declared unconstitutional.
Bestowing the powers of defining who the winner is and the loser, to only a few people, and that is the bench. The Supreme Court is 7, and the other, like for example, the High Court is 1. I mean, it will really be messy in this country.
Osoro, in his argument, says that the clause violates Article 140 of the Constitution.
Ikipata kwamba kulikuwa na uhalifu ama kulikuwa na ubaya katika sheria, katika uchaguzi, inafaa kuamuru wale watu waende kupiga kura tena.
When the Supreme Court interprets the Constitution, it doesn't read a single provision in isolation. It reads the entire Constitution.
Kenya Kwanza's attempts to thwart the possibility of an Odinga presidency declared by the courts have also been seen in the presidential petition by former Gatundu South Member of Parliament Moses Kuria. Kuria wants the Supreme Court to find Odinga guilty of having committed an electoral offence through alleged violence by Odinga's agents at the Bomas of Kenya. If the court will find Odinga culpable, then the Azimio leader would not be granted the election certificate, even if a ballot recount places him as the apparent winner, owing to the strength of Clause 4B of Section 80 of the Elections Act.
The law in Kenya is that to prove someone has committed an election offence that is committed by their agent, you need to demonstrate 2 things. 1, that the person who committed the offence was a duly authorized agent. And 2, that the principal consented or knew about this offense and you could say facilitated it. So it is a high bar that has to be met by Moses Kuria, and the proof of any election offense is at a high standard of proof that is beyond reasonable doubt. In the event he is able to prove that Raila Odinga is liable or guilty of an election offense, and then you've also added, and in the event that the Supreme Court was to retally the votes and find Raila Odinga has won, will those 2 in the events stop him from being sworn in? And my answer is yes. But you see, those are 2 speculative situations, neither of which is very probable. But if they happen, then Moses Kuria's petition would have an effect.
Upon determination of the petitions, the Supreme Court may also dismiss them and uphold William Ruto's win. That would mean that the president-elect will be sworn in 7 days after such declaration. Consequently, the court may also nullify the election results and order for fresh elections within 60 days. Ibrahim Karanja, NTV.